Hi there, I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families in Massachusetts and New Hampshire. And today I want to talk to all of you about demystifying probate and the executor's roles. Now, when creating a last will and testament, also commonly called a will, one of the most important considerations is who to choose to serve as the executor or personal representative of your estate. Now, as the name implies, the role of the executor is to execute the instructions that you have provided in your will. You may give your chosen executor some discretionary powers in determining how your assets and money and property are to be distributed, but they have limited latitude to make independent decisions. Any deviation from their specified powers could cause a conflict in your estate that may lead to some legal consequences. Now, to avoid any unnecessary complications in the settling of your affairs, you want to take care to avoid ambiguous or unclear language in your will. If there are any doubts about your last wishes, the executor and the beneficiaries may wish to consult an estate planning lawyer to discuss the next steps. So let's begin with starting to talk about what happens with your will when you die. Now, upon the death of the testator or the person who made the will, the probate will be opened if that testator died owning accounts or property in their sole name and without a properly completed beneficiary designation form. Now, probate is the court-supervised process in which the testator's will is validated and administered. The person named as executor in the will initiates and carries out the probate process. The probate process can vary slightly from state to state, but it generally unfolds in the following manner. First, the death certificate is filed with the court. Second, the testator's will is submitted to the court and confirmed as being valid. Then a petition to initiate probate is filed. The court then gives the executor permission to gather, evaluate, and manage the testator's assets. The executor contacts beneficiaries to inform them that probate has begun. List of the deceased assets, debts, bills, and taxes are compiled and submitted to the court. The testator's outstanding debts and taxes are paid from the testator's assets. The remaining assets are then distributed to the beneficiaries, and then the estate is closed and the probate then ends. Now, these steps imply that the decedent has, in fact, left a will. But dying without a will, known as dying intestate, entails much greater court involvement. The court appoints an executor, identifies heirs, and determines who gets what. Dying intestate can even empower the state to choose the guardian of your minor children. Now, it may not be possible to avoid probate completely. For example, if a guardian appointment is required for a minor child, or if an executor must represent the decedent in a pending or a new lawsuit, or if the decedent died with assets solely in their name and without a designated beneficiary. Probate duration and cost, however, can be reduced through careful estate planning. So let's talk about the responsibilities of the executor or the personal rep. The executor named in a will is responsible for carrying out the testator's final wishes. The executor is a liaison between the probate estate and the probate court, as well as between the probate estate and the beneficiaries. Now, their duties include locating and valuing assets of the estate, paying debts, and distributing assets to beneficiaries in accordance with the instructions in the will. The executors owe a fiduciary duty to the estate and its beneficiaries that compels them to act in the best interest of both. Because an executor may also be a beneficiary of the estate, their actions may be scrutinized to ensure that they are acting fairly and legally. Now, there are times when an executor can use discretion. The executor must, to the best of their ability, carry out the directions expressly stated in the testator's will. They cannot make changes to the will, but there are cases where the executor can use discretion when settling an estate. The testator might explicitly give discretion to the executor, or the need to exercise discretion may arise due to some ambiguities in the will, as in some of these examples. Maybe the will gives the executor wide latitude to decide when to sell the testator's property. Maybe the will allows the executor to decide whether to convert assets to cash prior to distribution. Maybe the will states that reasonable and necessary repairs must be made to the testator's home prior to its sale or distribution. When using words such as reasonable or necessary, it may be too vague and leave the executor confused about exactly how to proceed. If the will is unclear, the executor should seek clarification from the court to assist with the interpretation. Anyone with a stake in the estate may also raise a legal challenge against the executor, asking the court to remove the executor or commencing probate litigation against them. When a gray area exists within the provisions of the will, and the executor acts in good faith and within the scope of their power and duties, the courts may uphold their actions. A petition to remove an executor or a lawsuit against the executor for breach of fiduciary duty will only succeed if there is evidence of misconduct, such as the executor explicitly going against the will or estate's interest, acting in their own best interest, or withholding an intended gift from a beneficiary. Now, while the executor and the beneficiaries cannot rewrite a testator's will after that testator has died, the beneficiaries may be able to mutually agree to modify what they receive from the estate. Making changes to distributions can be done using a document known as a non-judicial settlement agreement. A non-judicial settlement agreement is a contract that may be used whenever the beneficiaries agree that asset distribution should be different than what the will stipulates. So some of these situations are maybe as a strategy to minimize a beneficiary's inheritance tax. Maybe when the family wants to balance out unequal distributions among all beneficiaries, or to settle disputes about the distribution of assets. A non-judicial settlement agreement can be a way to resolve a loved one's legal challenge in the will. The court should respect this agreement if it meets applicable legal requirements. However, before signing an agreement to change the provisions of the will, the beneficiaries should consult with the probate attorney so they understand whether this type of agreement is legally recognized in their jurisdiction, along with what the implications and potential consequences would be. In addition to assisting with non-judicial settlement agreement, there are many issues related to probate that might require some attorney assistance. Executors, beneficiaries, and anyone who feels that they've been treated unfairly in a will may need to consult with a probate attorney about interpreting and administering the will, determining their rights and duties under state probate law, and potentially challenging the will in court. In addition, when creating your will, it is crucial that you set out your intentions in a way that minimizes the potential for conflict among everyone involved. So if you need to get legal help with a will or a probate issue, contact a qualified estate planning attorney in the state in which this person resided. I want to thank you for watching. I'm Attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate plannings for everyday families located in Massachusetts and New Hampshire.